Hi, I'm Kevin Randles and I'm here with your weekly video update. This week, commercial real estate legal experts at Allen Matkins took a closer look at a new law scheduled to take effect this summer that will impact commercial leases. Before we roll the video, I want to give you a heads up about our upcoming Western States CREF Conference. Save the date for this year's event, held September 25th through the 27th in Las Vegas. Go to www.cmba.com for more information. And now let's join Allen Matkins for this week's update.
Starting July 1st, 2013, all commercial leases in California must include a disability access provision.
Basically, that language specifies that the landlord now needs to tell the tenant whether or not the property that's going to be leased has been inspected by a CASP, which is a certified access specialist.
And if the property has been inspected by a CASP, then the lease must also state whether the property has or has not been determined to meet the applicable accessibility standards.
The new law comes from Senate Bill 1186, enacted in September 2012.
SB 1186 is intended to make it more difficult for plaintiffs' lawyers to perpetuate what we would call shakedown lawsuits.
SB 1186 focuses on creating stricter procedures for plaintiffs' attorneys to follow when alleging violations of disability access laws and reducing the minimum statutory damages that can be recovered if the property was inspected by a CASP and requirements were met.
The first thing you need to do is determine whether or not the applicable property or the subject property has been inspected by a certified access specialist. We need to find out how long ago that happened in order to determine whether that inspection is still relevant for purposes of SB 1186. Once you have determined that the property has or has not been inspected, if it has been inspected, you need to find out what did the inspection say. Are you in compliance with disability access codes or are you not? And that's going to dictate what needs to be put in the lease.
But it's important to remember that the new law does not require commercial property owners to have a CASP inspection performed on their properties. It simply requires them to disclose whether they have done one or not, and if they have done one, then whether the property has been determined to have met the applicable construction-related accessibility standards.
Regardless of the decision to have a CASP inspection performed, that decision will need to be disclosed in all newly executed leases as of July 1st.